the email first, but you go through the email and you click on that video link and then you go and sign up. All right. Okay, so if nobody has any more questions, we're just going to move on. And today I'm planning to have a little bit of discussion amongst all of you. But just remember that when one person is speaking, others should be considerate and listen to that person. Since we are online, when I speak, your voice is going to be muted, or when you speak, somebody else's voice is going to be muted. So instead of stepping on each other's feet, I think it's better that we give each other a chance to speak, okay? And some people who are not getting a chance to speak, you can still keep on chatting on type in the chat box, and other people should be able to see you. All right, moving on. All right, we discussed in the review that there are two types of crimes. There is a conduct crime and there's a result crime. Does anybody remember what is the difference between conduct and the result crime? Just briefly type it up. And also, what is the conduct? Right. In conduct crimes, only conduct counts. The law does not care whether there's a result that has occurred or not. They just know that the law has been broken. You have done something to break the law, and you are guilty. And compared to that, the result crime is where prosecution has to not just prove the conduct, the illegal conduct, but also the result that has been occurred. Action as well as the result should be proven. In Hayward, everybody should have read the case Hayward in 1908. Was it sufficient for the accused to threaten the person, his wife, who he was chasing after, to be found guilty, or they wanted to see whether something has happened to his wife as well or not? If we are talking about result and it was sufficient? Okay. Okay, we're going to read, in tort, you were going to read assault a little bit differently than in criminal law. So in Hayward, what happened was when he chased after her, she actually died of a heart attack due to a condition that none of them knew about. And it could have been fallen under the result crimes as well. But if you compare it to the assault, unless he has touched her, in certain circumstances, it would not have mattered. But it was a different circumstances. And when we talk about conduct, act and bodily movement, plus Hayward says that the bodily movement should be voluntary. It should not be as you are having a spasm or you are sleepwalking and you don't know what you're doing. You are under influence of some kind of medication and you are having a fit. That means that the muscle that you move voluntarily, knowing that I am moving my hand, I know I'm moving it. It's my voluntary action. So the action, bodily movement, or the action, it has to be voluntary, and it should not be a result of an involuntary action due to some kind of sickness, disease, spasm, or something that has caused it to have happened. Voluntarily initiation of the causal sequence. If it ends in harm, that person will normally be held accountable unless an act or even later transpires which renders the finding of accountability inappropriate. Excuse me 1 second. Sorry about that. Okay, another thing that we were seeing in the past lecture was foreseeable and foreseen consequences, which there's a very little difference in it. Foreseen are the ones that I know they are certain they are going to occur. If I'm going to swing my hand, it's going to hit you. That's foreseen, that I know it's going to happen. Foreseeable are the ones that I'm doing an act and I'm reasonable certain or reasonable believe that something is gonna come out of that action. If I put the bar soap on the floor, on the wet floor, it's foreseeable that somebody is gonna walk by and he's gonna slip off it. That's your foreseeability. So the consequences, when they talk about the bodily movement voluntarily and the consequences there, we see later in the cases that they both have been talked about. When we are talking about voluntary initiation of causal sequence, your analysis should be ask yourself that was defendant's act voluntary? Was he acting under some kind of spasm, some kind of fit that's been occurred, some kind of something that, for example, a medicine has made you do something. Okay, for example, there was a case in the United States that a person didn't know the reaction to the medication. He took a medication, and on the driving wheel, while he was driving, he just has a little blackout moment, and he kind of falls asleep on the steering wheel while his car was still driving, and he hit a pedestrian. He was found not guilty because he didn't know, first of all, that there were 2 points in that case that the medicine is going to have that effect. And second of all, he was not doing it on purpose. He just blacked out. He fell asleep and he just hit that pedestrian. Okay, other than that, the Hayward also said that the defendant should be in the mental and physical control of his actions. And unless something has happened after the defendant has already acted upon, and that would break the chain of causation, he is going to be found guilty. Defendant's act is the first link in the chain of causation which results in the injury. Defendant is therefore accountable for that injury unless a later act or event occurs which renders the finding of the accountability inappropriate. Any questions? All right. So causation, we talked about causation just a little bit. Some people were confused about the but-for test, and some people really figured it out what it is. I'm going to let you guys talk about it a little bit. If you guys want to, you can unmute yourself. I'm going to mute myself from here and talk to each other about what is the but-for test, what does the case of White say, and what happened in Dalloway. That's just the first line. Okay, go on.
I don't hear anyone, so I'll start with White. White is the case from 1910 regarding factual causation, and White put potassium cyanide in his mother's bedtime drink. When she was found dead the next morning, White was charged with murder, but it was eventually established that his mother had consumed very little of the poison, and she'd actually died coincidentally of natural causes. So I think, like, just going off my memory, he was found guilty initially, and then it went Court of Appeal found him guilty, and it went to House of Lords. Somebody correct me if I'm wrong. And House of Lords said basically he wasn't the cause of her death, so he couldn't be found guilty. I think he was charged with attempted murder though.
Hello. Anyone hear me? Let me explain here. So that's what people said. I think it deals mainly with the causation of like the conduct. Like when someone gets hurt and the person didn't directly inflict the injury or whatever to the person, to the victim, but his action actually caused it or something like that. And I think to refer to the case, it's like I should be can't remember the case, but I can explain it. But there was a lady who got who refused the blood transfusion, and was arguing in the court that the refusal to get transmission was the cause. I mean, the claimant argued it was a refusal to get the transmission that caused the death and not his conduct. Well, I think it was agreed that the Tinch rule was applied then, and it was eventually agreed upon that he was guilty of the act. So from right with that. That's my knowledge. Oh yeah. Well, before anybody speaks here, I would like to confirm something. In the case of House versus Target, actually the defense used his girlfriend to defend himself against the police from the police. But the rule applies in this case rather than the factual causation. Is it applicable when you say but for Target, would the girlfriend have sustained injuries or sustained the bullet injuries from the police?
Okay, so do you guys think that if there was an omission, not an act, if that omission would not have been there, means that if somebody has done something to prevent something and a damage has done or the harm has occurred, would that work the same way as the act would in the but-for test? Right, of course, it's going to work the same way because when we talk about action, we just don't talk about the action. We also talk about the omission, that where you are legally bound to do something that you chose not to do and a harm have been occurred. In an example, but there are a lot of nuances to that, but also just keep in mind always when you are analyzing that particular feature that you should have a legal duty to act, because a stranger does not have a there is no good Samaritan law. It does not have a duty to act for just a stranger. And if they didn't do it, they most probably, unless there is a very rare extreme circumstances, they are not going to be found guilty. So anyway, I'm still waiting for your whatever you asked. You can go on and type, Sammy, and I'll read it and I'll answer to that, or anybody can answer to that, because I'm sorry I couldn't hear you properly later on. So when we talk about action and the omission, the but-for case says that unless the person would have done it or not do it, the harm would not have occurred. But the factual causation, which it's not the only thing that prosecution has to prove. They also have to see whether the legal cause have occurred. Now, legal cause doesn't necessarily have to be confused as another action, like a chain of actions. Yes, they are a chain of actions in one action. For example, if I'm gonna push you outside the window, my action is to push. You're gonna fall backwards, and then you're gonna drop on the floor and you're gonna get hurt. What hurt you was the fall, but what happened in the fall? I pushed you and the fall happened. So I mean, sometimes this simple example is given to define the different actions that can connect the chain between the legal, factual, and legal causes. Legal cause doesn't necessarily have to be an extra that I have to go and push you again to do it, for example. Now, and later on we'll see how courts have defined it. There's also a de minimis principle that the courts have defined, and it says that, but if the result would have occurred irrespective of, chain of causation would not break unless if some act has been occurred irrespective of defendant's act. For example, we read about White, and what about do you think that if the heart attack would have caused because of that cyanide, the court would have ruled differently? Or if, for example, in White, she has given poison to his mom, and she has been taken to the hospital, but the doctor didn't act promptly, or the doctor was negligent, or the doctor didn't give her adequate medical help, do you think the defendant would have still been guilty? You can type it. Please mute your mic for now. Thank you. Okay. The extent of defense responsibility of fact. Okay. What extent is that? Your court says that there may be more than one factual cause of the result. However, not all factual causes will amount to be legal causes, but the prosecution must prove that the defendant's conduct was more than just a minimal cause. Right, so to speak, if the doctors, there's one test that if the doctor has, exactly, that's your extent, But your de minimis principle applies here, and it says that if the defendant's conduct, was more than just a minimal cause, that is your de minimis principle, more than a minimal cause of the prohibited consequences, then he's going to be found guilty. Sometimes law also disregard the negligible causes. For example, that in one of your cases that we're going to read, the inadequate medical intervention was not considered to be the cause. They just said that he was still liable. Another point that one of the cases make that the defendant will be the legal cause of the consequence if the conduct was an operating and substantial cause of the result. For example, if you remember in Smith, what happened in Smith, that a soldier was stabbed, and his friend took him to the hospital, to the clinic, but on the way he dropped the the victim choice. Okay, and when he took it for him for medical help, the medical help was inadequate, but the defendant was still convicted of murder. He appealed, however, and consenting that if the victim had received the correct medical treatment, he would not have been died. In Smith, the court said the stab wound was an operating cause of the death, and therefore the conviction was upheld. So they decided that it was substantial enough for him to die. Maybe the reason would have been that if he had received the medical help, he would have still been died, or it was too late to bring him to the hospital. Court have many reasons. When they analyze these situations, they also analyze that the original cause, was it substantial enough? Was it big enough to contribute to the actions or the factor and the legal cause of the defendant? For example, if you have a little cut on your finger, okay, it's bleeding, and you are taken to the hospital, but on the way the driver of the ambulance is driving negligently. He gets into an accident and the patient dies. Do you think in a common sense that a defendant who may have caused a little cut on your finger would be liable for that? Why not? It was not an operating cause of the accident, and de minimis principle will apply. It was not an operating and substantial cause of the result. Okay. Similarly, there are another two cases. I'm having trouble pronouncing this word. It's Malcherik and Steele. There are two cases that were decided in one appeal, and in both of these cases, the victims were being hurt. In one case, the person has stabbed his wife, and the other one, another man has sexually assaulted a woman and beat him with a stone on her head. In both cases, victim had been taken to the hospital and placed on life-supporting machines. And the doctors in the respective cases later switched off the life support machine, as both victims were not showing any activity in their brainstem. Okay, the defendant sought to argue that the doctor's actions constituted a novus actus intervenus, which means the intervening cause, that's breaking the chain of causation. And it was held, court said that no, it doesn't matter, and the defendants were found guilty. The test of the death is where the brainstem cells has died. Thus, at the time of switching off the machines, the court said, their brain have already been dead. So the cause of the doctor switching off their machines would not have been the intervening cause. Had these two victims have not been brain dead, there would have been some chances that they're going to revive. Okay, they were not completely on life support, so to speak. They were maybe just too fed or something. And then the doctors have turned the life support off, then it probably would have been taken into consideration. Yeah. Any questions? Okay. We also talked a little bit about problem cases. Problem cases happen where the court have to really decide and play with what is the legal cause, what is the factual cause, when something unforeseen has happened. Courts usually consider two things. That first is that where there are more than one causes that seems to have a cause the result, and the initial wrongful act of the defendant is still the legal cause if it is still substantial and operative cause, are still strongly influenced on the outcome. The second thing the courts also take into consideration is that the latter cause contributed will not prevent the initial cause being still operative, unless it is so independent of the initial act that it is going to break the chain. I have also put in another case in your case summary. It's called the case of Bing. It was that doctor's decision was not independent of the initial beating. Okay, as their decision of not operating on the ulcer was because of the beating. If the doctor had, for example, if the doctor has mistakenly given the victim a poison, which has caused his ulcer to rupture. That would have been independent cause, but because that he was so beat up and they just could not have operated at that time, it was too dangerous for them to operate on his ulcer. Because of the beating that he has taken, they decided not to. That was not an intervening cause. Okay. Another very important point that you guys all should remember: two terms that you can see. It's either you will see a thin skull rule or actual skull rule. As I explained in the last lecture, that how did we come up with the term of actual skull rule? It just means that take the victim as you find. For example, in Hayward, we saw that when the husband chased after his wife to threaten him, and he was going to say, "I'm going to kill you," and all that, and she ran and she had a heart attack because of the thyroid condition. And that thyroid condition, neither wife nor the husband, none of them knew about it, but she died of that condition. And the defendant could have said that, well, she didn't die because of my threat. She died because of the heart attack that caused because of the condition that I am not responsible for. But you know what? In that circumstances, the court is going to say, you don't choose that what condition your victims are. If you have decided to threat somebody with this kind of threat that it's going to scare the wife away, and you don't know that she is susceptible to the threat and she can get a heart attack because of that, then you are guilty. I mean, we don't get to choose how we find, the defendants don't get to choose how they find their victims. If they are prone to some minimal damage can cause a huge result, then that's what it is. Then they're going to be guilty for that. Okay, finally, we're going to be discussing supervening actions or the actions of third parties. Before we start, does anybody have a question? Nope? Nobody? Okay. Okay, so we saw in White that the defendant put poison in his mom's drink. So if we switch the hypothetical a little bit, let's say that he put poison in his mom's drink. She took a sip and she's walking around the house, and the robbers entered the house. And while she's about to take another sip of her drink, he shoots her and she dies. Who should be guilty of her death? The defendant or the robber? The robber. And would that break the chain of causation? Yes. Okay. And why would that break the chain of causation? She did drink a little bit, but she didn't die of the poison. She died of but the robber, okay, so if Robert takes the stand and says that, okay, if I was not going to shoot her, she was going to drink that milk and die anyways, would that hold up in the court? No, it won't. And that's what you call your third party exacerbating the harm. Some words are very hard for me to pronounce. Or when your third parties intervene and they do something that is completely independent of the act that the defendant has already committed, or he is foreseeing a result from that action, then the chain of causation is going to be broken and the defendant will not be liable. That will be your act of third party. Now, there are acts of third parties which is reacting to the danger caused by the defendant himself. For example, in Paget, where the defendant has used his young girlfriend who was pregnant as a human shield, and he started firing on the police, and the police fired back and it hit the girlfriend and she died. Okay, and here it's the defendant was still found guilty. The defendant said that the police have killed her, not the defendant, and the court said that the chain was not broken because the general rule is that the conduct of a doctor or somebody who is reacting to the action of the defendant is not going to break the chain, that the police acted in self-defense. If the girlfriend was not in front of them, when they shoot at the defendant, it probably would have hit the defendant. Okay. Or for example, if the girlfriend was somewhere away from him, okay, it probably would not have happened. But he caused that situation to emerge in this way, that when police fired back at him, it actually hit the girlfriend because the girlfriend was probably in front of him. So the chain of causation was not broken. In those cases, not broken. Another rule that we need to know is that but-for rule is always applicable. But-for, what prosecution has to do, they don't not just have to prove the but-for cause, they also have to prove the legal cause, which in a way means that they have to find out whether there was an intervening action that was supposed to be there to break the chain of causation. If there was not, or if it was just a minimal one, not significant enough, then yes, your defendant is going to be guilty. Okay, read the ruling of the packet in detail, and I will tell you. For the negligent medical treatment, all these cases that I have given you, some of them may not be under the heading of but-for rule, but the but-for rule is always going to be there. Okay, prosecution can't move on unless the but-for rule was not there. Negligent medical treatment. So the general rule is, as I have written on the slide that you can see, that the conduct of the doctor, even if negligent, does not release the defendant from liability. Okay. And a negligent doctor may himself be liable for civilly civilly negligible, or the negligent medical malpractice, for example, that we'll read in torts, or even may be criminally liable for gross negligence, manslaughter, that is, where the victim died. However, that would be a separate liability. It would not connect to the original liability of the defendant. Why is that? Can anybody tell me why is that? Why, if the doctor is negligent, they will not take it into consideration? Why did the court decide that? Yeah, but minimal cause by defendant's cause should not be minimal. It should be significant. The original defendant, the doctor's cause is minimal. It can be one, but what are the basis of courts to decide that as a general rule? It could be an exception, right? Why is it a general rule that negligent doctor is not liable for the original cause that has been raised by, or the action that the original defendant has taken? Okay. Some rules, okay, maybe there are substantial break in the causation. For example, like I said, if a doctor, that soldier who was stabbed, if he would have gotten a medical treatment on time, and there was a reason that he could have been saved, and he was not saved because of the inadequate medical treatment, do you think the doctor should be liable? There can be a substantial break in the chain. But sometimes when courts make law, they make some laws on the basis of facts and laws and the general crimes and the whatever we read in the first lecture, that to keep the environment safe, people safe. Sometimes there are policy considerations. Okay. In this case as well, policy considerations largely govern the area of causation, and the court does not desire an original attacker to escape just because your doctor was negligent, just because your doctor didn't do his job properly. That doesn't mean the original person who has stabbed you or the original person who has put cyanide in your drink should go free. Shouldn't he go free, right? He shouldn't, right? Do you guys agree? Right, right. Of course, yes, policy plays the role. Why shouldn't the defendant go free then? I mean, he wasn't really the ultimate reason the victim died. It was the doctor. Why should we not let the defendant go free? Okay. He has committed the crime, and we don't want criminals to walk out freely in the society because remember, all the crimes are not, even though we are hurting just one particular person in the crime, he is not the only one who's been suffering. The idea is that when a criminal acts to hurt somebody, he is actually putting the whole society in danger. So we do not want the original criminal to go free just because the doctor was negligent. Otherwise, we can't make the society safe. Maybe he'll go out and just do another crime. He he can get away with one. Why wouldn't he not do another one? Intention to do grievous bodily harm, of course. He had an intention to do a bad act, and that's why. But the focus is not just on the victim in that policy. The focus is on the whole society. We don't want bad guys to roam around freely. We want them to be punished, whether or not they have completely caused the death. Doesn't mean that a victim has to die. Okay, doesn't mean the victim has to die because of his own action, but we want him to be punished because he did something bad. The case of Smith, it suggests that there is a scope of negligent treatment that could have broken the chain of causation, but the case is an extreme example, not likely to be applied when somebody is grossly negligent. If the doctor is grossly negligent and there is no way that you can just take the liability away from him, then yes, okay, fine. And most of the times when you don't have an intention, for example, in involuntary manslaughter, you didn't intend to hurt him, which we will read it in the recklessness. If you didn't intend to hurt or kill somebody, it happened by mistake, for example, negligence or something. But he did his part, he did his part, he took the victim to the hospital, but the doctor was too lazy to operate on him, and he died. So yeah, in those circumstances, of course, the policy is not going to come in play. They are going to punish the doctor as well for the death of that victim. But the original defendant who has caused the original harm will probably go in for involuntary manslaughter, or he probably will go in for maybe gross negligence or something like that. A defendant is always allowed his defenses. It is against the public policy, the law, the rule of law, that you do not give a defendant a chance to raise his defenses. He has to raise defenses. He can't go forward unless he raises defenses. If he has a defense, he is going to raise it. Nobody can tell him that you're not going to raise your defenses, or you can't. Public policy, another public policy is that the defendant also gets a fair justice system. He gets the fair treatment in the court. Just because he committed a crime doesn't mean that he should not be given all his rights. It's his right, and it will be given. Yes, you can't take it away from him. Okay, so let me give you an example. You got into a fight with the victim, okay? Or defendant got into a fight with the victim, and you leave the victim unconscious and leave him in the park in the sunny afternoon. There is no way it's going to rain. There is no way the storm is going to hit. But what happens is that somehow the lightning struck and the victim dies. What is that? Do you think that the defendant is going to be liable? Okay, Joel, why would the victim be liable? Depends. Okay, does it depend? Let me mute myself and Joel and Sandeep and Femi. Why don't you guys go first, and later everyone else can join, okay? Joel, I'm going to have you go first and describe why do you think that he's going to be liable. I'm going to mute myself. You can unmute yourself now.
Had he not beat up the victim would have been able to move and leave the path. Therefore, the lightning would not have been able to cause his death. So, initially, the defendant was partly liable for having the victim there, which caused his death. That's it.
I'm not sure if I'm supposed to start there, but I think that the lightning should not have anything to do with what transpired between the defendant and the victim, because it depends upon how bad he was hit by the defendant. If defendant caused a substantial bodily injury or something which could have caused the death, yes, then the defendant is liable. But otherwise, any harm by the lightning which caused the death, the defendant cannot be held responsible. I would think so. That's all. Thanks.
Okay. Okay, that's a natural event. That's true. You guys are right. It's a natural event, but it's going to be a reading comprehension test. When you read your facts, read them very, very, very. Pay really good attention to the facts. Let me repeat my fact pattern. Defendant beat the victim and knock him unconscious and leave him in the park on a sunny afternoon. Sunny afternoon. Later on, for some reason, lightning struck and killed the victim. Do you think that, okay, yeah, Abby is on the point here now that on a sunny afternoon, there are no clouds on the sky. It's really sunny and it's about 100 degrees outside. I cannot foresee that there's going to be a lightning storm coming our way, okay, unless it's Florida or somewhere where it just comes on. Defendant is not going to be responsible for that. Why? Because it was an unforeseeable event. Secondly, it was an act of God that was unforeseeable, okay? Had it been, I'm sorry, can you mute yourself, please? Thank you. Had it been that they had a fight on a beach, defendant is not liable, but I wanted you to give me the reasoning as well. Conclusion, sometimes we have great conclusions. Sometimes we say yes and no, but what examiner wants you to do is to explain why you got to that conclusion. You also have to, Sandy, you also have to keep in mind that what events that we are saying that going to break the chain or not break the chain are foreseeable. If I know, in the next example, what I was going to say is, if we had a fight and the defendant leaves the victim on the beach, where when the tides are coming high and it's stormy, and he just leaves him on the beach and walks away. The tides become really high, lightning is striking too, and it's a storm, and in one of the tidal waves, the victim just washes away, he drowns and he dies. Do you think that would break the chain? It's also a natural event. It will not break the chain? Right. Why would not it break the chain? Good. High tide is anticipated. Yes. Foreseeability. Remember the word foreseeability. When you are making your analysis in the exam, you are going to be expected to write what action is foreseeable, act or event, what act or event is not foreseeable. Okay? All right. What's next? Natural events. We did the natural events, and that will be your foreseeable and unforeseeable natural causes. I haven't timed myself. How long we have been on? Can somebody tell me? Probably about 40 minutes, right? Okay. All right. So another category. Okay, thank you. Another category is supervening actions of the victim. Okay, supervening actions of the victim. There are two cases on point in that. It's the Holland, 1841, and Blow, 1975. In Holland, there was a serious assault with an iron bar, and the victim, when he was taken to the hospital, he refused to submit to the amputation of the finger. The doctor said that it's gonna turn into an infection and you're gonna get tetanus, and tetanus is deadly, so we better take care of it. But the victim said, no, I don't want to do it. Okay, I don't want to do it. And eventually what happened? Sure enough, she dies of the tetanus, or he died of the tetanus. In Blow, 1975, that's a California case, I think, or not. Defendant stabbed the victim, causing serious blood loss, but she was at that time doing some kind of religious practice, and she refused the blood transfusion because of the religious reasons. And what happened? She dies of the blood loss. In that case, defendant argued that he was not the cause of victim's death. The cause was victim's refusal. The Court of Appeal rejected that argument, stating that the defendant must take the victim as he finds him, and the defendant's act was still a substantial and operative cause of death. Again, remember the autopsy report, okay? Why do you think they refused? They could have just say that, okay, give me blood transfusion, or she could have said that, okay, well, save my life and cut my finger off. Why they did not do that? It was their own free will to not submit to the treatment, and that's why they died, although they were already told. Why would the defendant should still be liable? Very briefly, can anybody tell me why? Shouldn't it be the victim who should be liable for his own death? Right. The general rule is that when the victim does something which is unexpected and prejudicial to their prospect of recovery, this will not break the chain of causation. Okay? And also that the court said that in the Court of Appeal said that in the Blue, that you take the victim as you find him, and defendant's act was still substantial. It was still the operating cause, and if they did something that was prejudicial to their recovery, it's not going to break the chain, okay? Even if it was unforeseeable, was it foreseeable that Holland was going to refuse to get the amputation? Or was it foreseeable that the girl in the blue was going to refuse to get transfusion? Was it foreseeable? Not necessarily foreseeable. I don't know how it would be foreseeable. You would think that if I'm sick, I want to get better and I'm going to submit to. It was unforeseeable by the defendant, but that doesn't matter whether it was unforeseeable or not. It's just going to be that it's not going to break the chain because we're still going to hold the defendant liable because he put them in that place in the first place. And also, you find the victim as he or she is. You don't get to choose your victim. In Roberts, a woman jumped from a moving vehicle to escape sexual assault from defendant. Do you think that's foreseeable? Would that be foreseeable if a person is, yes, and yes, if you are going to, somebody is going to threaten me with sexual assault, then yes, it's foreseeable that I'm going to try to save myself from it, right? Now, there is a case on file where a girl in the, I don't know if you guys have read it or not, it's called the Dhaliwal case. In this case, what happened was that a woman committed suicide after the year of abuse and rape. The court struggled a little bit in the decision that whether the abuse, her suicide was foreseeable or not. What do you guys think? Would a suicide in reaction to rape would be foreseeable or not? Right. Circumstances matter in case to case basis. Normally, you would not think that a person who is raped not everyone who gets raped will commit suicide, but in certain circumstances, yes. In Dhaliwal, what happens was she was subjected to abuse, physical and mental abuse for years in the family, and when she was raped, she just went ahead and committed suicide, and in that case, they said that escape cases, yeah, you can't do that. Well, what about the drug cases? A person who has, in drug cases, if a person, okay, so I am a heroin addict, okay? I fill out a syringe with heroin and give it to somebody else, and they just injected themselves and later died. Am I going to be liable for that? Why not, Sandeep? Right. If it was just fun, okay. Okay, so the point here is this victim made a voluntary choice to inject himself with that syringe. D wasn't liable in that case. Okay. Yes, victim had his own choice. He was not under any duress or anything like that. He injected himself and he died. So it will break the chain of causation. Okay? All right, finally, we are on to mens rea. Any questions so far before we move on to mens rea? No? Okay. All right. So mens rea, as we know, is guilty mind, right? We read it before. But that's not the only thing in mens rea. There are more than one element of mens rea in criminal offense that are present. For example, when we read about theft, if you guys remember the definition of theft from that code, there are two components there. for mens rea or your intention. It was the dishonesty. I dishonestly decide to do something, and then I had an intention to permanently deprive. I am going to take this thing away, but I'm not going to give it back. So it's not just that I'm going to go steal something. There are more than one components of elements of mens rea in one criminal offense present usually, and it all obviously varies from case to case. It can mean a lot of things, and there's a typo here in this slide. It's not recklessly, it's recklessly. Okay. Intentionally, you will see a lot of words for that. You will see intentionally, recklessly, maliciously, knowingly, believing, dishonestly. You will see a lot of different words. Okay, reasonable suspicion. I knew it was reasonably foreseeable. Everybody could have seen it. And always read the fact pattern. Always read the fact pattern and to figure out whether there was a guilty mind or not. There are certain exceptions which we're going to study later, and some of you I remember know from previous lectures about strict liability offenses. We're going to be reading about strict liability in tort as well as in the criminal law. So strict liability offenses are your exceptions to mens rea rule. Okay. All right. It's going to be a little bit confusing for you if you have not grasped the idea, but trust me, it's not as difficult. It's really simple. There are two concepts that we discuss law by. Usually, it's the objective and subjective. When we compare, for example, in tort, we compare the actions of defendant as a reasonable person. What would a reasonable person in my condition, with my education, with my background, with my mental development, would think about that? Or would they have done this action, particular action in these particular circumstances? That is your objectivity, where we are looking at and analyzing defendant's action as compared to a hypothetical reasonable person. For example, in tort, we are also going to learn if a 10-year-old child commits something, he commits a tort, he does something to, for example, trespass, okay? He trespasses into somebody else's property. How are we going to determine that? The courts look at that, okay, so whether usually a 10-year-old child who is up to the mental development of this child of whoever the defendant is, and would he have done the trespass in these conditions? Would he have gone overboard to grab his ball? Would he have climbed the wall or the fence over to the neighbor's yard to go and touch the puppy? Okay, would he have done that? That's how you figure out or determine whether objectively defendant was liable for his actions or not. Just like it is negligence and carelessness. Would a person, a reasonable person in my condition with my age would have been careless as I was or not? Subjectively is when a defendant saw or perceived as what the defendant saw or perceived as a coincidence. What was in defendant's mind? What did he think? Did he intend to go over the fence and touch that puppy? Did he intend, or was he reckless enough? Oh, it's okay. It's a pit bull. It's not gonna do anything. I'm just gonna go over and I'm just gonna tease the dog, neighbor's dog. And what happens is the neighbor's dog bites him. Okay? Was he reckless? Was he not careful? Did he intend to do that? He may not intentionally have caused the dog to bite him, but he was careless enough up to the point where a reasonable person in his mind also would see that, oh no, the pit bull can bite me. And also, did he appreciate the result? If he thought in somewhere in his mind that the dog can very well bite me if I'm going to go tease him, then subjectively and objectively, both ways, we're going to find that, yes, defendant have the mens rea present. Their subjectivity is considered in your traditional core crimes, in your murder and all that crimes also. When we talk about recklessness, I'm just going to go back to the previous slide for a second. Oops. Okay, when we talk about recklessness, recklessness also means that it's considered as your intention, which we're going to read later on in the lecture, that intention, whether he intended to, if he was not, for example, drunk, would he have known that if he's going to jump on the dance floor, he's going to hurt that person who's dancing? That is also, he still decided to take the risk. He knew that he was going to hurt somebody, but he still decided to take the risk. He appreciated the risk, okay? All right, we're going to go through this slide, and then we're going to switch off for the next lecture, and we're going to continue next week. Let's just differentiate between the intention and motive. Intention and motives are not the same. Before I start to explain it, can somebody tell me what is the difference between motive and intention? Yeah, good. You actually explained everything I was going to say. Great job, everyone. Intention lies at the heart of criminal liability. Usually in criminal liability, motive is almost always ignored. They don't care. The courts don't care that I killed that person so he doesn't hurt my dog, okay? They just know that I killed that person. I intended to kill him. I intended to pull the trigger when I shoot that person. It's the heart of criminal liability. Yes, but motive helps in when you're investigating the case. When you find that, okay, if you find the motive, you're going to know that what the intention was. My motive was to save my dog. Okay, so what do I do to save my dog? I could have done anything, but I was too far away to throw something at him. The only thing I could possibly do to stop him from hurting my dog is to shoot him. Okay, so I fired a gun and the victim dies. My dog is safe. But the law doesn't care whether I did it for good reasons or bad reasons. They just know that I killed a person. There was a case where a person raped a little 4-year-old little girl, and then to wash away all the evidence from the body, he just dumps the body into a river or a stream that was really fast flowing. He knew that the girl was going to die. His motive was not to kill him. His motive was just to take the evidence away. But and we're going to read it in recklessness, but he did just intend to put her in the water, but he knew she was going to die, and he was convicted, okay? It doesn't matter what your motive is. It does not matter what your motive is. As long as you have the intention to kill, as long as you have the intention to hurt somebody, and you actually did something, then an overact, which is called, you have done something to go on with your plan of hurting somebody, you are going to be guilty, okay? In theory, criminal law ignores motive. Any questions up to this point? Any questions? No one has any questions? Okay. How was the lecture today? Was it hard? Did everybody understand the but for? Criminal law usually ignores motive when there is a liability. They don't take motive into consideration when they are supposed to held the criminal liable. They just look at your intention. Like I said, your motive is supposed to go where to find the intention, but they don't care what your motive is when deciding whether the defendant is guilty or not. In theory, not in practice, in theory. Okay? Because as somebody already said that as a rule of thumb, the motive provides the actions, the actor's reasons for forming the intention. So unless you have the motive, you probably do not have the intention in many cases, not always, but like in involuntary manslaughter or in some other mistake cases, you don't have the motive, but it just happens. So in theory, criminal law most often ignores motive, but they look at the motive to find out whether the intention was there or not. But they don't go by motive to convict a defendant. They will go by intention. I would appreciate and prefer that you let me know if you're going to miss a lecture or if you're going to be late, because obviously, if like you guys expect me to be here on time and prepared, I expect all of you to be here to be on time and prepared. And you don't have to post it where everybody can see it. You can privately message me, or you can just send me an email. Okay. 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 Anything else? I'll post it to prepare for next class or what to read for next class. And there are a few more case summaries I have for you from Andrea. I'm going to post that online. Carl, I will email it to you. But for everybody else, it's going to be on the group, Facebook group. And Abby, I think she hasn't been been approved to join in yet. We'll approve you to join in to the group and where you can see all the activities. Yeah, about the lecture being posted, please be patient. Sometimes it's technology. Sometimes it takes a little bit time to process. And since it's supposed to be not, remain public, it's only for you guys who are participating in the criminal law lecture. It takes a little bit time to sometimes for the video to go out, but it will be posted. Okay. Anything else? Facebook information to your email? Okay. It's actually, if you have the lecture, the first lecture, if you go to the first lecture, it's there too. I'll send you the information. Actually, I'll send it to you right now and you can click on it. I don't know when I will be able to get back on Facebook. So hang tight. Here is the link to the Facebook group, the criminal law group, where we post our questions and upcoming updates and questions, answers, notes, everything. Carl, if you can easily, I would really suggest that you go and Joel, are you not on Facebook? Okay, out of all you people, who is not on Facebook other than Carl? Okay, I guess just Carl. Okay, Carl, there is another link for the main group that our law school, SWBIL has. When you go and join the criminal law group, the private group, please go on and join this main group too. And here's the link to that. Okay. All these updates are usually we prefer to post it online where everybody can see it and where they can interact with the teachers and to each other. That's the purpose. And if easily, Carl, you can join Facebook, it's great. Otherwise, I'll send you the further updates in the email for Carl. Other than that, everything else you can find on the group. And if you have any questions, feel free to email me. Feel free to post online, private message me. Some of you already do or have done it. Yeah, I'm pretty prompt most of the time in the replying and answering to the questions. But if you don't hear from me for a few hours, please don't panic. I always will come back and get back to you, okay? All right, if you don't have any more questions, I'm just gonna sign myself off from here. I will let it on for a little bit, so you guys, if you want to talk, you guys can talk to each other, okay?